This is Virginia Zodiac. Mr. Keck, I understand you're going to argue Ms. Zodiac's motion to default. Is that correct?
Correct, Your Honor.
All right, Mr. Keck, go ahead, please.
First of all, thank you, Your Honor, for taking the time to allow us this hearing on this motion to open default. Your Honor, we're only here today because plaintiff refuses to cooperate and chooses instead to escalate what was really a minor disagreement among friends into this vengeful litigation, which he's determined to win at all costs. Unfortunately, a perfect storm of errors prevented us from responding to her meritless allegations more quickly. But rather than impose a drastic sanction of default and prevent Ms. Zodiac from defending herself in this matter due to mere technicality, we ask you to follow Georgia's liberal policy for opening default and use your broad discretion to do so here, especially since plaintiffs won't be prejudiced at all as a result of the delay. We believe you should open default because although Ms. Zodiac was neglectful, her neglect was not so severe that it was inexcusable as a matter of law. There are three reasons why this is the case. First, our actions upon discovering the default were reasonably prompt. Secondly, Ms. Zodiac fell victim to several administrative errors. And finally, she relied on our law partners' assurances that the matter was being properly handled. Your Honor, would you like me to familiarize you with the facts of the case?
No, Mr. Keck, I've read the briefs. I'm familiar. Thank you.
Okay. Your Honor, as I'm sure you know, Georgia courts routinely open default under Section 55B of the Georgia Civil Practice Act. It's because default judgment is a drastic sanction that really should be invoked only in extreme situations, which the Georgia Court of Appeals has repeatedly reminded us as recently as 2011 in Thomas v. Brown. This case simply is not an extreme situation warranting such a harsh result. In fact, as that same court pointed out in Patel v. Gupta, the defendant need not make out an extremely good case of excusable neglect. All that's necessary is a reasonable excuse.
But counsel, you're certainly aware that the Georgia Court of Appeals have reversed several trial courts and found that, in fact, those courts abused their discretion. So it's not an absolute discretion that I have, correct?
Correct. In rare circumstances, the Court of Appeals may find that the situation is extreme and this drastic sanction should be applied. Here, certainly, we have a reasonable excuse because we acted promptly once we realized the matter had gone into default. And as the Georgia Court of Appeals pointed out in Ewing v. Johnson in 1985, the court should generally set aside default when the defendant acts with reasonable promptness and alleges a meritorious defense. Once Mr. Weinstein learned that the complaint had been misrouted to the firm's spam folders, he contacted opposing counsel the same day in order to address the situation. Prompt action after learning the case has gone into default weighs heavily in favor of opening default, as the Georgia Court of Appeals pointed out in Mars v. Moore in 1993 and Cobb County Fair Association v. Boyle in 1977. Also, the client Ms. Zodiac acted promptly after discovering that the matter had gone into default. As soon as she found her misfiled complaint, she contacted Mr. Weinstein immediately. So on two separate occasions.
But Counselor, if she had responded promptly when she received the summons, we wouldn't be here. So I'm not particularly persuaded by the argument that she responded promptly once she discovered that she was in default. And how does that offset the fact that she was already in default?
Well, certainly she didn't immediately call a lawyer when she received the complaint. She had 30 days to respond. But she did not take the complaint and throw it away, cast it aside, and intentionally decide, I'm not going to deal with this. She put a note on it, which clearly exhibited her intent to deal with the matter. And unfortunately, what happened was that she placed it on her desk and it became lost amongst her other papers. And Georgia courts generally refuse to penalize defendants who fall victim to unrealized administrative errors, as the Georgia Court of Appeals pointed out in Exxon Court v. Thomason. Ms. Zodiac should not be punished for mere administrative errors. Some of these were beyond her control.
But they were beyond her control, Counselor. I read her testimony, and it seems to me that the basis for all of this neglect at that point was that she simply was just too busy. I think she repeatedly said that in her testimony to deal with this. And we know that press of business is not a valid defense.
No question, Your Honor, that being too busy is not a valid defense. And certainly, this isn't a situation where she had the complaint in front of her and consciously decided that she was too busy to deal with the matter and threw it in the trash. She clearly intended to deal with the matter later. In fact, courts generally look for evidence that the defendant acted with intent and manifested conscious indifference to or willful disregard of the legal process, as the Georgia Court of Appeals pointed out in Rucker versus O'Connor. In fact, after that, she fell victim to a second administrative error, where through no fault of her own, the complaint she emailed to Mr. Weinstock was misrouted to the firm's spam folder. Very similarly to the case in...
Well, Counsel, I would accept that what happened at your end would be validly considered administrative error. Certainly, your firm is entitled to have filters. But let's go back to her administrative error, her mistake. She just simply placed the summons on her desk and it got lost amongst the papers. That's her defense?
That is correct, Your Honor.
And so if any of us have bills that we get, we put them on our desk and papers pile up on top of them, we don't pay them, there are consequences for that failure to pay, correct?
Indeed, Your Honor. It's just a question of what the consequences are. If you think about using your analogy, if I don't pay my electric bill for a month, the consequences are that the electric gets shut off. But if immediately after the electric getting shut off, I contact the electric company and ask them to turn the electricity back on and pay my bill, the electricity comes back on. The consequences here would be permanent. It's a very different situation. In fact, we're basically asking you to do the same thing as if I had called the electric company to get the electricity turned back on. Basically, we are, in fact, throwing ourselves on the mercy of the court here and asking you to give our client a chance to defend herself, because she was a victim not only of one error, but of several errors. As you acknowledged, it wasn't her fault that the complaint wound up in our firm's spam folder, and on top of that, shortly thereafter...
But it was her fault that she didn't follow up to ensure that it was received, correct?
Your Honor, she did speak with the law partner at our firm shortly thereafter, and she should be excused for relying on our law partner's assurances that the matter was being handled.
I guess I'm just a bit concerned with cases such as Flournoy or Williams that suggest that simply transmitting a complaint in the summons without following up with the proper person is simply not excusable neglect.
Well, there's two issues there. First of all, this isn't a case where she just cast the complaint off in the cyber world and never followed up with anyone. She did speak with a law person or a law partner at our firm who, to the reasonable layperson, would be a proper person. It's not unreasonable for someone outside the field of law to believe that law partners talk to each other and know what their law partners are doing. And it's not unreasonable for a layperson, when a lawyer tells them, I'm sure this matter is being handled, that the matter is in fact being handled.
But she didn't, the law partner didn't have any knowledge, in fact, that the complaint was even received. So her assurance that it was being handled was just based on an assumption that it was being received.
That very well may be true, Your Honor, but Virginia Zodiac had no way of knowing that. And a reasonable person in her position would have no way of knowing that. And as the Georgia Court of Appeals pointed out in Pinehurst Baptist Church versus Murray, the law should not impose policies that encourage individuals to distrust the parties with whom they deal with in the ordinary course of business. It's especially true for lawyers. We don't want to encourage policies that encourage the distrust of lawyers. If a lawyer at the law firm that's handling your case tells you the matter's being handled, I think we want to encourage policies that lead the public to believe that they can trust their lawyers and that the matter's in fact being handled. Your Honor, for these reasons, we believe that any one of these is sufficient grounds to open the fault, and we ask that you please give our client the opportunity to defend herself in this case. Thank you, Your Honor.
Thank you, Mr. Kay.